Well, hello everyone. On behalf of Policy Exchange, let me welcome you here today for this lecture. If we've not met, my name is Richard Eakins, Professor of Law and Constitutional Government in the University of Oxford, and it's been my privilege for the last 5 years to lead Policy Exchange's Judicial Power Project. As many of you will know, the project aims to maintain the balance of powers in the Westminster Constitution and to address some of the ways in which the rise of judicial power may put that balance in risk. And our work has at times considered the jurisprudence of the European Court of Human Rights, as well as its domestic reception by way of the Human Rights Act and related case law. And one particular focus of Policy Exchange's research for some time has been litigation concerning military action, especially military operations abroad, but also taking in the legacy of the Northern Ireland Troubles. So we're very pleased indeed to be able to host John Larkin QC today to discuss the European Convention on Human Rights and its bearing on Northern Ireland in particular and the United Kingdom at large. John has been Attorney General for Northern Ireland for almost 10 years, with a practice that unsurprisingly has involved much constitutional law and human rights litigation. John studied in Queen's University Belfast, and in addition to a distinguished career in legal practice, he served for several years as Reid Professor of Criminal Law in Trinity College, Dublin. He's the first person separately to hold the office of Attorney General for Northern Ireland since its functions were assumed by the Attorney General for England and Wales back in 1972. This is the second time John's spoken on our platform, having joined us last year to debate with Jonathan Sumption and others the merits of the Supreme Court's prorogation judgment. We're honoured by your presence here today, John, and we look forward very much to hearing what you have to say.
Thank you very much, Richard. Good afternoon. It's both an honour and a pleasure to give this lecture at Policy Exchange. The Judicial Power Project of Policy Exchange has been both a first responder and I think a specialised giver of care in a critical case of constitutional malaise. If our Constitution recovers a healthy sense of balance, that is to say its traditional sense of balance, it will have owed an enormous debt to this project and to Policy Exchange as a whole. Few of us would, I suppose, now think that the besetting fault of our time was a tendency to overpraise the traditional constitutional order of the United Kingdom. It's much more common, for example, to find lawyers and others praising the recommendation of some unaccountable UN committee or a judicial decision drawing on the work of such a committee than the work, for example, of the Commons or Lords. But I think it has to be said that the constitutional history and tradition, the living history and tradition of the United Kingdom shows a commitment to remove abuses and address grievances that need fear comparison with no European state. And this history and tradition, I suggest, tend to disprove the existence of any need, far less a pressing or urgent need, for the UK to receive enforceable moral addresses from any international institution. One quick example will, I think, suffice. Muslim women in the United Kingdom are free to wear a face-covering veil in the public square without fear of prosecution. This is not true, for example, of France, of Belgium. Muslim women in the UK have not needed the European Convention on Human Rights to avoid being penalised for this sartorial expression of their faith. And as we know from the Grand Chamber decision of the Strasbourg Court in SAS against France and later cases, the European Court of Human Rights has been no use at all to Muslim women in France or Belgium who run the risk of penalisation for wearing garments that their faith, in their view, requires of them. And of course, to say this is not for a moment to claim that the institutions of the UK have always acted justly, or that the justice system and the political process between them have always succeeded in removing abuses or in redressing well-founded grievances. nor is it to claim that we have nothing or little to learn from other states or indeed from international institutions. Nor yet is it to claim that we should not accept help, including information and learning from our friends, and refuse to act jointly with them when our common interests call for us to do so. My starting point, it seems to me, is a modest one, and it is this. There is reason to believe, based on our constitutional experience and tradition, that in the UK we have the capacity to deal well with the issues and problems that arise within this polity. And so from that premise, that starting point, I want to look at an aspect of an important provision of the European Convention on Human Rights, Article 2, and what that might mean for how policy for the legacy of the Northern Ireland Troubles is made. That's the core of this talk. And I want to precede that core with some reflection on the more general problems that have arisen from bringing rights home, that is, the partial domestication of the European Convention on Human Rights through the Human Rights Act 1998. And I want to end then with some suggestions about what we might do now. So, as is well known, the title of the October 1997 White Paper, which accompanied the Human Rights Bill of that year, was Rights Brought Home, the Human Rights Bill. And I think with the passage of time, it has become clearer that the Human Rights Act 1998 has been less important as a conveyor home of rights under the European Convention than as a tool for the domestic judicial expansion of those rights, with the result that there are cases or legal arguments that the government of the United Kingdom would win at Strasbourg, that public authorities will lose in London, Belfast, Edinburgh and Cardiff. And that is at least in part for two reasons. The first is that the meaning of any provision in the Convention that is also included in Schedule 1 of the Human Rights Act is subject to two layers, at least two layers, of interpretation. The first layer is the Strasbourg layer. By Article 32 of the ECHR, the Convention, in all cases properly before it, the Article 32 of the Convention gives the court competence to decide whether it has jurisdiction or not, and it has jurisdiction to interpret the Convention in all cases properly before it. So under the Convention, at least in its present form, and I'll return to that, the European Court of Human Rights has the last word on the meaning and application of the words making up the Convention. But, as Lord Kerr explained in Commissioner of Police of the Metropolis against DSD, this is Lord Kerr, the Human Rights Act introduced to the law of the United Kingdom the European Convention on Human Rights and Fundamental Freedoms by making the Convention part of national law so that the rights became domestic rights. Because the rights are domestic, they must be given effect according to the correct interpretation of the domestic statute. Note that phrase, the correct interpretation of the domestic statute. And he cites Lord Hoffman in Re G. The court's first duty is to give effect to the domestic statute according to what they consider to be its proper meaning, even if its provisions are in the same language as the international instrument which is interpreted in Strasbourg. Lord Kerr went further. Reticence by the courts of the UK, he said, to decide whether a convention right has been violated would be an abnegation of our statutory obligation under Section 6 of the Human Rights Act. And in saying this, as he did in 2018, he was echoing his own extrajudicial words in a 2012 lecture when he said this: Section 6 of the Human Rights Act leaves no alternative to courts when called upon to adjudicate on claims to a convention right. That statutory obligation, to be effective, must carry with it the requirement that the court determine if the convention right has the effect claimed for, whether or not Strasbourg has pronounced upon it. And in the same 2012 lecture, Lord Kerr said that the court, that is, the national court, must choose the interpretation that most closely accords with its reasoned view of the content of the convention right. It should not be deflected from a more generous interpretation if it considers that such an interpretation is the right one, solely because the matter can always be put right by Strasbourg. Now, the reference to the matter being put right by Strasbourg is perhaps a nod to what Lord Browne said in Alsgany. And he set out a principled objection to the domestic courts going ahead of Strasbourg in interpreting the convention for themselves. Lord Browne said this: "There seems to me indeed a greater danger in the National Court construing the convention too generously in favour of an applicant than in construing it too narrowly. In the former event, the mistake will necessarily stand. The member state cannot itself go to Strasbourg to have it corrected. In the latter event, however, where convention rights have been denied by too narrow a construction, the aggrieved individual can have the decision corrected in Strasbourg." Now, to my mind, there is no ready or satisfactory answer to this juridical lopsidedness identified by Lord Browne. The product of this lopsidedness, consequential on a domestic readiness to surpass Strasbourg, is a kind of doctrinal ratchet in which domestic advancements beyond the then extant Strasbourg line of authority will never be repudiated by the Strasbourg court, and the absence of repudiation by Strasbourg itself forms a notch from which still further domestic advances will move forward. And this takes me to the second problem with bringing rights home: the willingness of domestic courts to find that domestic measures that would fall within the UK's margin of appreciation at Strasbourg, and therefore the UK would win in Strasbourg, need not, by virtue of that, survive national judicial scrutiny. Lord Mance said this in the Welsh recovery of medical costs for asbestos diseases reference. At the domestic level, says Lord Mance, the margin of appreciation is not applicable, and the domestic court is not under the same disadvantages of physical and cultural distance as an international court. The fact that a measure is within a national legislature's margin of appreciation is not conclusive of proportionality when a national court is examining a measure at the national level. And he cites, as Lord Kerr before him cited, the observations of the House of Lords in Re G. But, as we've seen very recently, even when the UK Supreme Court seeks to measure and test domestic instruments by reference to the Strasbourg standard, problems can still occur. And in the case of last year, our DA against the Secretary of State for Work and Pensions, a majority of the Supreme Court held that the justification of the adverse effects for rules for entitled to welfare benefits, another universal credit case, should be by reference to whether these rules were manifestly without reasonable foundation. Lady Hale dissented on the application of the test, not its correctness, and Lord Kerr proposed a test of his own. And in delivering the main judgment, it might be thought that Lord Wilson gave perhaps a hostage to fortune. Because when, having said that to justify what would otherwise be a discriminatory effect of a rule governing entitlement to welfare benefits, the sole question, he said, was whether the rule was manifestly without reasonable foundation. And he added the admonition, let there be no future doubt about it. Of course, that really is a hostage to fortune. Because even though none of the justices in that case, including the minority, Lady Hale and Lord Kerr, nobody thought that the test that Strasbourg had itself propounded for such a case was anything other than manifestly without reasonable foundation. The Strasbourg court itself, some few months later, has since indicated that the manifestly without reasonable foundation test does not have the general applicability that all of the members of the Supreme Court thought that it did. And for what it's worth, I thought that their reading of the Strasbourg jurisprudence on that was the correct one. But in JD and A against the United Kingdom, a decision of the first section of October last year, and a referral to the Grand Chamber has been refused, in February, the Strasbourg Court made it clear that it has limited its acceptance to respect the legislature's policy choice as not manifestly without reasonable foundation to circumstances where an alleged difference in treatment resulted from a transitional measure forming part of a scheme carried out in order to correct an inequality. So it's if you're getting rid of past inequality, the test, according to Strasbourg now, is manifestly without reasonable foundation. Otherwise, says the court has held that because of the particular vulnerability of persons with disabilities, such discriminatory treatment would require very weighty reasons. That's the Strasbourg phrase, very weighty reasons to be justified. And of course, it will be for the Strasbourg court to say whether or not the policy reasons put forward by the state are very weighty or not. And in one of the two cases, JD and A, it found that they were not. And when a court, any court, can put the pall of a human rights breach over a policy outcome for which it considers the reasons not sufficiently weighty, we know, or we ought to know, I think, that the scope for politically accountable policy making has pro tanto been diminished. So, let's turn to the core. Let's turn to Article 2 and Northern Ireland. Some context. From 1966 to 2006, over 3,700 people lost their lives as a result of the Northern Ireland Troubles. Of these, 2,152 were killed by Republican terrorists, 1,112 by Loyalist terrorists, 310 by the Army, and 51 by the Royal Ulster Constabulary. The true figure of those who died as a result of the Troubles is of course likely to be higher, and the number of those hurt by the Troubles must be enormous. Figures are available on a year-to-year basis historically for those prosecuted in respect of Troubles-related offences, but these offer no real guide as to the numbers of persons who do in fact bear criminal responsibility for the murders of the Troubles. In a case in which, for example, one person has been made amenable for one murder, there may be 4 or 5, many more in some cases, who bear criminal responsibility, either as primary or secondary parties to that killing. And that's true not only of murder, but of all Troubles-related offences. And of course, as matters stand under our law at present, these cases must all be considered open and investigated when reasonable to do so, and where the evidence following investigation so permits. When files go to the DPP, they will have to determine whether or not the evidential test is met and whether the public interest requires prosecution, and if so, for what offences. There is, bluntly, at common law, no limitation period for indictable offences. So let me pause there and observe that, setting aside the obvious point that the passage of time can normally be taken to diminish the prospects of a successful criminal investigation, it would not be open to the police at common law to close a case. That is to say, in respect of any serious offence, they would not look at that case even if someone were to come to them with vital evidence showing that X had been involved in the commission of that offence. And I think that leads us then to the question: what difference has Article 2 of the Convention made, Article 2 which protects the right to life, made to the investigation of Troubles-related cases? I have to immediately begin any answer to that question by pointing out that the difference comes not from the text of Article 2, as agreed by the Member States of the Council of Europe, but from the text as in effect rewritten by the European Court of Human Rights. There are no procedural obligations in the text of Article 2, and it can never, I think, be sufficiently emphasised that the procedural aspect of Article 2 is a creation of the Court and not the product of agreement by the Member States of the Council of Europe. And it is no coincidence, I think, that this creation has emerged from two cases connected with the Northern Ireland Troubles. The first is, of course, McCann and others against the United Kingdom, the Death on the Rock case. And in that case, by 10 judicial votes to 9, the Strasbourg court held that there had been a violation of the Article 2 rights of the applicants. In Article 2, for the first time, the court held that Article 2 requires by implication, note that, by implication, that there should be some form of effective official investigation when individuals have been killed as a result of the use of force by inter alia agents of the state. Now, the judgment in McCann was described to me by a senior member of the Strasbourg Court's registry a few years ago as the equivalent of an additional protocol to the Convention. That statement is as significant as it is accurate. And when I jocosely taxed the author of the description a year after I first heard it, the reply was, but I think it's a good development. And my rejoinder was it may or may not be, but it was for the states to decide whether it was a good development or not, and not for the court. For present purposes, two things should be noted about the decision in McCann. Firstly, that no breach of the new adjectival or procedural duty was found in that case. And secondly, the court didn't tell us what form such an investigation should take and under what conditions it should be conducted. For that, we had to wait until Jordan, another Northern Ireland case. Jordan against the United Kingdom. The Strasbourg court unanimously held that there had been a violation of Article 2 because of failings in the investigative process, and in so doing, the court identified some of the features that the investigation, first recognised as a requirement in McCann, should possess. And for this lecture, I want to focus on only one of those, effectiveness, but I invite you to note that in Jordan, the specification of the component parts of the procedural obligation does plainly partake of a legislative quality. This is not a judicial determination, it is a specification of future requirements, much more akin to the work of a legislature than, I suggest, the work of a court. So on efficiency, the court said that the investigation must also be effective in the sense that it is capable of leading to a determination of whether the force used in such cases was or was not justified in the circumstances, and to the identification and punishment of those responsible. It's worth remembering, and certainly something which is important for me, that while McCann concerned purely a challenge to the inquest proceedings, Jordan was a challenge across a wider front. There were three targets in Jordan. Firstly, the police investigation for a lack of independence. Two, the Director of Public Prosecution's role being limited by the police investigation and by the failure to publish reasons for not prosecuting. And three, the inquest delays, the limited scope of the inquest inquiry, lack of legal aid for the inquest, lack of access to documents, the non-compellability of certain witnesses, and the use of public interest immunity certificates in inquests. So remember that the inquest in Jordan was only one of three litigation targets. And in paragraph 130 of its judgment, the court observed, on inquests, notwithstanding the useful fact-finding function that an inquest may provide in some cases, the court considers that in this case it could play no effective role in the identification and punishment of any criminal offences which may have occurred, and in that respect it falls short of the requirements of Article 2. Now, if I read that passage, if I read paragraph 130 correctly, this is a finding that the inquest in Northern Ireland had not, or at least had not in Jordan, any effective role in discharging the Article 2 procedural obligations of identifying and punishing persons responsible for the unlawful taking of life. Given this structural finding, it's curious that the court then goes on in paragraphs 132 to 140 to discuss, in respect of the inquest, the absence of legal aid, delay, issues about disclosure of documents, and issues around the public interest immunity certificates. And if the inquest cannot, as the court said it could not in paragraph 30, discharge the Article 2 functions, then changes in the matters discussed in the subsequent paragraphs cannot alter what is a fundamental barrier, I think, to the inquest being an effective vehicle for delivery of the procedural rights discovered and now developed in the Jordan case. That view is, I think, strengthened by a reading of Janowicz and Russia. Janowicz concerned claims against Russia by descendants of Polish citizens detained and murdered in Katyn near Smolensk in April and May 1940. The applicants claimed breaches of the duty under Article 2 to hold an adequate and efficient investigation, and they also claimed under Article 3, which prohibits torture or inhuman or degrading treatment or punishment with respect to the denial of information to them about the fate of their relatives. Since the Russian Federation had only ratified the convention in May 1998, the claim could only have been even theoretically possible through the rather odd doctrinal porthole opened up by the Grand Chamber decision in Chile against Slovenia. Again, those of us who take a fairly classical approach to international law and the Vienna Convention are astonished by the retrospective application of the convention at all, but the court seems very keen to ensure that it's not left out of any potentially interesting case. Nonetheless, there are limits. Janowicz saw the claims under Article 2 rejected on the ground that the convention hadn't applied when the crimes occurred and shouldn't be made to apply retrospectively for procedural purposes on this occasion, and the court substantively rejected the claims under Article 3. What's important for this lecture is what the Grand Chamber in Janowicz says about the investigative duty under Article 2. There is a very significant passage in paragraph 143 of Janowicz where the court gives some elucidation of what's meant by the Article 2 investigation. It says that the procedural obligation in Article 2 covers acts undertaken in the framework of criminal, civil, administrative or disciplinary proceedings which are capable of leading to the identification and punishment of those responsible or to an award of compensation to the injured party. Thus far, this may be thought to be little more than one can read in paragraph 30 of Jordan, but then the court goes on. This definition, said the court, operates to the exclusion of other types of inquiries that may be carried out for other purposes, such as establishing historical truth. Now, while it is true that a coroner can refer a case to the Director of Public Prosecutions, an inquest is not designed to be and is not a substitute for a proper criminal justice investigation. While you can keep coal in the bath is not designed for that purpose. And this has caused me, since Janowicz, to refer requests for inquests to the Public Prosecution Service or the Police Service of Northern Ireland, where what is at issue is an allegation of the deliberate taking of life. And what the PPS and the PSNI do are, as with the decisions that I take in relation to inquests, governed by the law in its present form. If, by way of a coda to paragraph 143 of Janowicz and the rejection for Article 2 purposes of truth-finding inquiries, it's proper to observe that although the Strasbourg Court has been, as we've seen, incredibly creative in drawing up new procedural rights from the textually unpromising substance of Article 2, it has, with one exception, refrained from interpreting either Article 2 or Article 3 so as to create a freestanding right to truth. And the court has consistently, as respects Article 2, emphasised both the practical, predominantly criminal justice colour of the procedural aspect of Article 2 and the exclusion that we've seen in paragraph 143 of Janowicz. Now, the one exception I referred to occurred in the context of a ruling on the procedural obligation under Article 3. This was because the applicant was not dead, wasn't in danger of death, but he had claimed to have suffered torture or inhuman or degrading treatment. This is the case of Abu Zubaydiyah against Lithuania. And it's one of the CIA sort of black site cases. And in that case, the court said, furthermore, where allegations of serious human rights violations are involved in the investigation, the right to the truth regarding the relevant circumstances of the case does not belong solely to the victim of the crime and his or her family, but also to other victims of similar violations and the general public who have the right to know what has happened. Mark that, the right to know what has happened. Now, this is to advance well beyond the rights guaranteed by the Convention and indeed created by the court in cases such as McCann and Jordan by creating or extending a right to the truth, which, insofar as it existed at all, was subordinate to and dependent on a criminal justice purpose of the procedural obligation in Article 2. And it goes beyond that, beyond those who have victim status in Strasbourg, the victim of the crime and his family, to other victims of similar violations, and much further still, to the general public. General public which has, in the opinion of the first section of the court, a free-standing right to truth conferred upon it, quite independently of Article 3 of the Convention, and this would apply also to Article 2, as well as to Article 34, which provides for the standing requirement for the Strasbourg court. And against that, and hopefully, I emphasise against that, a recent confirmation of the continued correctness so far of the Janovich distinction comes in the recent admissibility decision in Chong, which is a kind of the Strasbourg version of the KU decision in the Supreme Court. And in Chong, the court observed that in that case, which concerned the killings that took place during the Malayan emergency, any investigation at this point in time would likely be limited to establishing the truth of what happened at Batang Kali, and would therefore fall outside the definition of procedural acts and omissions set out in Janovich. So if Strasbourg has not yet identified a freestanding right to truth, we cannot be certain that it will not do so in future. And in the meantime, I have so far seen off all judicial review challenges to my decisions declining to direct an inquest, but I'm awaiting one decision from the Court of Appeal against a High Court victory, and one leave hearing has yet to take place. But if Strasbourg were to find that Article 2 or Article 3 encompassed a right to truth, and who can say that the court will not so find, then I would find it hard as a Section 6 public authority under the Human Rights Act to do anything else but grant requests for inquests in virtually every application made to me for that purpose. Such a shift would also lead to increased demands for public inquiries, more generally, and with those demands for public inquiries plausibly backed with the threat of litigation. So, finally, in this last section, I want to outline 3 suggestions. There is little that is original in any of these suggestions, since in one way or another they have all been put forward by me or others before. 2 relate to our domestic law, the Human Rights Act, and our law on the use of force, and the 3rd relates to the European Convention on Human Rights itself. So the first suggestion is that Section 22 of the Human Rights Act should be amended by a Section 22(4)(a) to provide that no claim shall be founded on any of the Convention rights in respect of a death occurring before October the 2nd, 2000, the date on which the Act came into force. This would not, of course, prevent a claim being made directly to the Strasbourg Court, but as I have suggested, there may at least sometimes be less to fear from the Strasbourg Court than from the domestic application of the rights in Schedule 1 to the Human Rights Act. And in this context, it's perhaps worthwhile to note Article 35(3)(b) of the European Convention. And this requires the Strasbourg Court to declare inadmissible any application if it considers that the applicant has not suffered a significant disadvantage unless respect for human rights requires a hearing on the merits, and provided that the case has been duly considered by a domestic tribunal. Interestingly and importantly, the proviso relating to due consideration by a domestic tribunal will go once Protocol 15 is in force. So if you have influence with the governments of Italy and Bosnia, please exert it. The second suggestion is a new model establishing a certification process for the commencement or continuation of troubles-related cases in Northern Ireland. And at the core of the new model is the principle that no investigations or proceedings with respect to a qualifying offence, that is an offence connected with the Northern Ireland Troubles, will commence or continue, if it has already commenced, without a certificate. And the certification process applies the existing law under Section 3 of the Criminal Law Act, Northern Ireland, 1967, and the Common Law of Self-Defence, with the following additional elements. The subjective belief of the suspect, to use that shorthand, which already applies to the existence of circumstances, is extended for procedural purposes only to the reasonableness of the force used. The law already under Section 3 permits the accused to rely on the circumstances as they were honestly, even if unreasonably, believed by him to exist. For example, I honestly thought his paintbrush was a machine gun and the person holding it was going to shoot me. That sentiment will, if possibly true, even if absurd, justify lethal action by a potential accused as our law currently stands. The present protection for honest belief in circumstances will extend to an honest belief in reasonableness and legality of response. Secondly, a belief by the suspect at the time lethal force was used that the force was unreasonable or unlawful will result in certification. And when certification occurs, the investigation or trial will proceed with the standard substantive application of Section 3 of the 1967 Act, so far as relevant, or the law on self-defence, insofar as additional to that and as relevant. This new provision simply applies a heightened filter to all cases involving qualifying offences, irrespective of the job description of the suspect. It will, in all likelihood, prevent investigations or prosecutions where what is at issue is a split-second error of judgment, and it will place no barrier whatsoever in the way of prosecuting those who set out deliberately to kill. The certification process would be given the same protection as a High Court order in order to avoid the problems that can arise, often especially in Northern Ireland, from collateral litigation. It's of course possible that the Legacy Commissioner, the person doing the certification, could be a judge of the High Court or Court of Appeal in Northern Ireland. One might want to consider limited provision for an appeal only on the ground of bad faith, both as a protection against collateral litigation challenge as well as a safeguard against a decision, however improbable, that was in fact taken in bad faith. On the other hand, if the certifying commissioner is a judge of the High Court or Court of Appeal, there may be no need for any appeal whatsoever. And the suggestion described here has been referred to in summary form in the valuable policy exchange paper by Professor Richard Eakins and others, protecting those who serve. But my object in advancing the suggestion is to protect all of us, those who served and those who did not, from potential lopsidedness in our criminal justice system, and to do so in a way that is reflective of a sound and almost universally held moral sense in the community. The Northern Ireland community, I'm quite sure, views split-second errors of judgment, viewed with a benefit of hindsight, quite differently from those who set out to kill someone. The third suggestion relates to the future shape of the European Convention itself. I suggest that a future protocol should re-establish the primacy of sovereign states as the creators of international obligations under the European Convention on Human Rights. This would be done by enabling states to enter interpretive declarations within 1 month of final judgments addressed to them, in which they could reject the interpretations of the Convention proposed by the Court. The interpretive declarations would be effective as respects the state entering them and any other state that indicated agreement with that interpretive declaration. But they would not free the state from any monetary obligations, damages and costs contained in the judgment. So thus far the judgment would essentially have an arbitral effect. Issues for future debate include the extent to which a new judgment, relying on an old but objectionable interpretation of the Convention, could be subjected to the protocol process, and the extent to which other states should have a role in limiting the use of the interpretive declaration. For example, could unanimous opposition by all other states prevent an interpretive declaration from taking effect? But put shortly, this proposal would mean that where states A and B have agreed proposition X, no other player, that is the court, can come along and tell them that in fact X means Z. If states want to agree that there should, for example, be an enforceable right to truth, fine, but one should not, and one could not, with such a protocol, have one foisted on states by the Strasbourg Court. I am not, at all, to borrow the title of the Susan Sontag essay, against interpretation, but I am very much against substituting one text for another and describing that process of substitution as interpretation. Bluntly, it isn't interpretation to play Haydn when the concert programme and the score call for Mozart. Finally, and I hope consistently with my expression of concern at domestic judicial advances on Strasbourg, let me express concern also at the scope for judicial lawmaking that might arise from a British Bill of Rights. We don't need one. Not only do we not need one, its creation and existence would not only lead to an expansion of judicial lawmaking, but would, I think, be likely to dull or diffuse that keen concern for our rights that ought to exist among members of Parliament. And it is they, members of Parliament, and not judges, who Blackstone regarded, the great Blackstone regarded, and I think rightly regarded, as the guardians of our Constitution. Thank you very much. So, we've time, I think, for some questions. Yeah. Yes.
Thank you. John Ingham of the Daily Express. You've mentioned the legacy investigations. Are there legal grounds for stopping investigations, for instance, statutes of limitation?
No.
No. I mean, when Boris Johnson's talking about ending the witch hunt, has he got legal grounds to do it? And if not, how could he do it?
Well, he could change the law through Parliament. Yeah.
Thanks, John. Just on your third point about allowing states to reject interpretations of the court, how far does that go? Because obviously, potentially, states could agree, either by themselves or with others, as I understand it, to undermine some of the essential principles of the Convention, which defeats the entire purpose of the Convention, which is to protect those fundamental human rights.
Well, two things. Firstly, under the Vienna Convention, a declaration can't be used to undermine the text, so there is already an international law limitation on that. Secondly, I think in any event, the greatest protection against human rights abuses comes not from a text, but from a healthy culture which respects human rights. And no one, I think, looks at the text of the European Convention as agreed by sovereign states and thinks that there's anything wrong with that. The issue is always how it has been interpreted in that broad sense by the court. Yes. So, yes.
Yes, John. Given the prospect of the right to truth opening up a new wave of inquests, plus the fact that the Lord Chief has sanctioned, I think, 50-odd inquests to be revived, plus the fact that the civil courts are now, as I understand it, becoming almost paralysed by litigants reverting to the civil process because they haven't got satisfaction, if you like, in the criminal process. Have you reinforced your, it's an obvious question, view of whatever it was 10 years ago that really it is time to put a lid on all this?
Well, I think my view about the correct approach, correct in inverted commas approach to legacy, is that the most correct approach is that which commands the widest possible support. I did put forward the often summarised as the line in the sand or drawing a line approach. The problem with that was it didn't command sufficiently wide support. Now, a friend of mine of an evangelical cast of mind and speech said to me, he said, well, did people come to you like Nicodemus under cover of darkness and tell you they agreed with you? Yes, they did, but they tended not to say so, or many of them tended not to say so out loud. And actually, when one thinks about it, there is a strong moral case that of course there is a strong moral case that people who do awful things shouldn't escape punishment. And that's why the suggestion here, I think, who knows, has a chance of commanding much wider moral support. To adopt the language of Lord Keane, it's not perfect, but there is unlikely to be a perfect solution to the issue of legacy. Yes.
It's Jonathan Ames from the Times. Sorry, just to follow up on my colleagues from my counterpart from the Express's question. I mean, can you just be clear, your view on Boris Johnson's commitment so far regarding legacy prosecutions? Is he not, you're saying he needs to change the law?
Well, if he wishes to give effect to that, the cases, as I've said, we don't have a statute of limitations. And under the existing law, we will trundle on as we have been trundling on. And of course, it's open to any government that can command a majority in both houses of Parliament to effect a change in the law in accordance with its policy wishes.
So is his, I don't want to put you too much on the spot, but is his commitment so far not strong enough if he wants to achieve that?
Well, you see, you have made a disadvantage because I don't have the text of his commitment. Hence, the answer must be inevitably given in fairly general terms, that if he wants to change the law, he can do so. But if the law is not changed, then we remain as we are.
Brian Wolfe.
Brian.
Hi, formerly BBC and Constitution Unit. This is very much a layman's question. Does certification, as you suggest, does it require legislation or not?
It would, of course it would.
Right, yeah. And what therefore are the prospects given the fact that in the Assembly these issues are very divisive, and certainly in the right wing of the Conservative Party, what do you think? You must have some calculation on the likelihood of such legislation succeeding. And finally, to what extent do you think that the very severe attacks on the existing process on grounds of lopsidedness are likely to satisfy what is mainly unionist opinion?
Well, sort of working in reverse, I'm not sure you're right in relation to unionist opinion alone, and that's why I think that there is a broad moral consensus across the community in Northern Ireland that there is a distinction between the split-second error of judgment and putting a bomb under somebody's car, for example. Pardon?
Yeah.
Oh, did you get that, Brian? So that there's a yeah. So I think working back from that, if that is indeed reflective of a widespread moral consensus, then that, I think, increases the likelihood, one can't go further than that it will get some traction.
Testing.
Jonathan? Yeah. Is this? Oh. Again, in reverse order, I don't think realistically there is anything to fear from the International Criminal Court, bearing in mind the relevant chronology and the Rome Statute when it comes into force. So very few, if any, killings by the security forces will be captured by that. In relation to statutes of limitation, I think you're right. I mean, I think there would be certainly a convention issue, to put it very mildly, about saying, well, there's a statute of limitations for you, and you, but not you over here. And that's why I am attracted to a solution which doesn't depend upon the garments that people wore when they went out to work, but actually on what they did and what their state of mind was when they did it. Okay, I think maybe time for one more question, and then I'll hand over to Lord Brown. So. Yes.
I'm very troubled by the Strasbourg decision, which looks at the question of manifestly without reason. It's not difficult to put most government policy decisions which affect welfare to find some form of discrimination, direct or indiscriminate. Because general legislation will always adversely impact upon one group or another. And that means if that's the policy adopted, that in principle it'll be for the judges to say what in their view is appropriate. Now, of course, they'll be able to say, well, we do give deference, we pay deference to Parliament and to the decision makers. They're better placed to make the decisions. But having a manifestly without reasonable foundation really identifies a very limited role that the courts will play in those circumstances. Apart from airing the concern, my question is, why did this case go to the Grand Chamber? And are you confident that issue will go to the Grand Chamber in the near future?
Well, it didn't go in JD&A, so the Grand Chamber must perforce have rejected the request that was made, I think, by the UK government, quite understandably, to take it there. And the difficulty is that that rather suggests, by implication, I know lots of final courts of appeal, especially the US Supreme Court, say, oh, you don't draw any conclusions from our denial of certiorari, for example. But nonetheless, it does, Strasbourg, I think, has given a very powerful hint that that approach, the approach of the first section, has broader judicial support. So that's going to make it very difficult indeed to get that shifted, I think. Okay, well, I hand over to Lord Brown to...
I've been given up to 5 minutes, so if I get lost in my own loquaciousness, please shout at me after 5 minutes. My principal task, of course, is to give a vote of thanks to John, and I do so, and that's the easy part. I mean, it was the most fascinating, challenging, stimulating talk. It provides a wonderful foundation for an awful lot of, in future, more informed discussion than we've had on several of these subjects. It covers an absolutely vast canvas, of course. I mean, we could have a seminar on about half a dozen different aspects of it. Valuable insights, both generally and, of course, not least from John's particular perspective in the role he has as Attorney General for Northern Ireland. I don't pretend to agree with everything that he said. I don't want to say much about judicial overreach. I mean, I'm much readier to agree that Strasbourg have overreached than our domestic courts have overreached, but to a degree, I mean, I'm prepared to accept, to a degree, that too. I don't agree with all his proposed solutions. I think that the certification has terrible problems. I think the idea of a protocol where member states can somehow agree between themselves to put limitations on any certainly further development of the convention. I mean, I don't think these are going to fly, frankly. I do, and I'll come back to this in a very short time, I do think there is room for some modification, some amendment of our domestic law, of the Human Rights Act itself. Before I go any further, I mean, can I just please associate myself with those who deplore the treatment that we are continuing to impose on our the legacy cases? I mean, no doubt it's deeply indiscreet, but the thought that we're going to be prosecuting this man Hutchings for a murder, alleged murder committed when he was a young subaltern 46 years ago is astonishing. I mean, I read the judgment of the Supreme Court last year as to whether there should be a jury or not, and that judgment seemed to be entirely right and certainly beyond any sensible criticism. But the striking fact is it's 46 years since this killing, and there have already been investigations. There's no suggestion, as I understand it, of some dramatic new, previously undiscovered evidence in the case and so forth. Now, as to amending the bill, John, of course, deals with it because this is the relevant consideration in Northern Ireland, where there's no argument but that the Convention applies on a temporal question. And I am inclined, too, to agree, actually, it would be a good idea to limit the application to post the Act. Time for a mea culpa, because I was, having got it right originally in which was it, McCurr in 2004. We then in the Supreme Court in McCoy, as a result of this Shilley case which John mentioned, Shilley v. Slovenia, we departed from the decision in McCurr, and we said that not only is this a detachable adjectival obligation to investigate, but it can apply pre the Act. Alan Roger rightly dissented in that case. To a limited extent, but much more limited, a mea culpa in respect of the other thing I would do, which is actually to limit the Act territorially. Now, back in the days, Al Scaney, when was that now? We were in the House of Lords still, so pre-09. Four of us, Tom Bingham, the wisest amongst us dissenting, probably rightly, said that actually we should, in terms of extraterritoriality of the Act, we should track the Convention. But in those days, the Convention was understood as in the Bankovitz case, and it only extended extraterritorially to embassies, British registered ships, and of course in the infamous Bahamusa case to a British base. So I would in fact return by amending the Act to that, not totally within the UK, but just with those very limited exceptions. I feel I'm probably reached my time. I think it's back to my principal task, which is again to thank John for a really brilliant and illuminating judgment, and I think then we adjourn. So thank you very much, John.